Everyone more call about over daily update TV. So now we should you made and subscribe to my YouTube channel, like and share for comment, share comment section. Said it be I me beji brain ya kame tifo ni afifo ni no. Justice Tanko Amadu. Still the man is insisting say the decision of Chief Justice should be reversed. We release a statement me mam kasa ne nyetintin statement ne letter ne nkasa mu a watwere nyanse decision a speaker aye maame Torkono edibai and the majority of the Supreme Court panel judges no ono ne Amadu and the one other component no they object and they totally disagree because they found the ruling not to be accurate, not to be proper, not to be what genuinely authentically and as authentic. It will raise the objection, serious one pa. It yebeko TV3 key point for credit mom. Into the whole and justice Amadu Tanko nin same nyina waturo nyina no omo nyamse busua nsem no de enye adwuma because or say the fundamental disagreement or the disagreement in the first place is not about the Supreme Court and there was a ruling the same way. The High Court have to take responsibility of this issue and the Supreme Court and someone already no say the genuine was the sorry, the ruling is not genuine and that's authentic because objections are all raising on the statement in much as a Chief Justice Torkono and then the majority panel on the case that very day no omunyina nkasa and as they shouldn't have the authority to rule this case because the constitution mandating the High Court to look forward into such cases from the legislature and as from the Parliament House. You got never comment show them and some they be into asem no say omo be boa to agu say omo be den because ni nyina nze asem no omo montu na chese speaker enye free man na chese the ruling no should stand ni nyina no ni tintin as asem no omo mongu na speaker free man na the ruling should stand or still proceed because speaker the and as the declaration is based on constitution. That's the whole the statement, everything that he's reading on. That's what it means.
Say Act 300 is not law or what? Me, I just don't understand this decision there. No.
Why you pull Act 300? I'll bring in lawyer Sefa now because it's also a private legal practitioner. I left that out. Hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in the majority that not only do I fundamentally disagree with their conclusion, I, with all due respect, also find the decision an aberration to the established and accepted judicial position of this court, which with profound respect, I hope in no distant future, the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed. In fact, he's hoping that this decision as reached on this matter, the majority decision will be reversed soon. The conclusion I have arrived at should in no way be construed as suggesting that the Supreme Court is not the appropriate forum vested with jurisdiction to interpret and or enforce the Constitution in appropriate circumstances. The point which I unequivocally emphasize is that it is the same Constitution, 1992, which vested exclusive power in the Supreme Court in matters of interpretation and enforcement of its provisions, which also designed the mechanism for this court to assume jurisdiction. Thus, although this court has a general jurisdiction to interpret and enforce provisions of the Constitution, there are situations, such as in the instant case where the procedure, and he makes emphasis on the procedure adopted in invoking the Supreme Court's interpretive and enforcement jurisdiction, has deprived the court of the power to exercise that jurisdiction. In fact, it goes on to say a number of things, but I'll pause here because as far what exactly was the original relief that Alexander Fenyomaken went to the Supreme Court seeking? Because
file.
right? Even before the speaker delivered his decision, correct? Right?
Yes.
Did you amend that particular earlier that's application?
Well,
before the Supreme Court?
It needs not amended before.
Why is that?
Before the Supreme Court could have assumed jurisdiction to have dealt.
Sorry. In fact, it was Justice Yawada Kwasari who actually wrote this judgment, and then also for and on behalf of those who ruled in favor of the plaintiff, and Justice N.S. Gaiwu, who was actually a subject of conversation when the speaker's application was thrown out. Those who dissented, Justice Amadou Tanko and Justice Avril Lovelace Johnson, they dissented on the matter of jurisdiction. And if you look at on the matter of jurisdiction, I'm going to put that on the screen as well, but on the benefit of those who are listening to us right now on the radio. On the matter of jurisdiction, when the speaker's application was ruled upon and thrown out, according to the 5 justices who sat on that matter, the writ filed by the majority leader was seeking an interpretation of Article 97(1) G and H, which was purely a matter of law and not whether a member of parliament was validly elected. That even if the case was filed at the High Court, an interpretation of Article 97(1) G and H became a bone of contention, the High Court, by Article 132 of the 1992 Constitution, was required to stay proceedings and refer the issue of constitutional interpretation to the Supreme Court for determination. It is therefore misinformation, in their view, and misapprehension of law for the applicant to represent that Supreme Court has no jurisdiction to give interpretation on a provision of the Constitution which has attracted different meanings. So, Counsel, on this matter of jurisdiction, recall when it came up, we had a conversation. The Supreme Court, in this 109-page ruling, if you look at page 33, in fact, it was from page 12 all the way to page 36 or about, addressing the matter of jurisdiction, essentially making the point that to the extent that there was disagreement on the matter of interpretation of Article 97(1) G and H, then the Supreme Court's jurisdiction was properly invoked. Why do you say otherwise?
Well,
I'll start off with Lawyer Martin.
Oh, okay.
Good one.
The jurisdiction, what do I say?
Yes.
Look, the matter of jurisdiction, let's just repeat this. I keep telling you that, or making the submission that in law, if the Supreme Court wants to find jurisdiction, it's easy to find. In the same way, if they want to decline, it's easy to do. So let's set a bit of the parameters so that we understand. I always say that let's remember, just like, and it's good, we can relate to the Bible. You see the way the provision in Micah, the one about tithes, you see how some pastors will interpret it to mean that you must bring 10% of your income every month to the church. Other pastors will say no, it just means that give what you can give. That's the same way the Constitution is. We have so many rules, okay? There is the ideal one, but you will never get lawyers to agree. So what we will call ideal, purposive interpretation, even that one, a court can set out to say I'm doing purposive interpretation. And yet, what is actually happening is not purposive. So all I'm saying is that our idiosyncrasies, ideological positions, prejudices, everything of a judge, it's also reflected in judgments. You may not see, the judge will not say, my ideological view is this, or my philosophical view is this, so it's affecting the judgment. No, but they all do. So the jurisdiction matter, I always said it from day one that bottom line is that it's the Supreme Court that has the power. So if they want to find jurisdiction, they'll say, yes, there's jurisdiction. Because, ask Bobby, we go there, sometimes you couch your case, thinking that, yes, you've created a jurisdictional matter for them. They'll look at it and say, no, they don't think so. That's their opinion. So what I'm saying is that it's not a straight jacket. It's fluid. It's subject to everybody's interpretation. So the fact that they say they have jurisdiction, I don't believe so. Look, what we are struggling, so I don't agree with the Supreme Court that there's jurisdiction.
Why is that?
But I agree that because we belong to different schools of thought, they have the right to what? Disagree, and they can hold a different opinion. And that's why I say that. So in all of this, the real understanding of what is going on is you look at how they are appointed. This is the very reason for which they are appointed. A president looks at the various judges and he will choose those who think like him, those who support his viewpoints, those who reason like him. Then we say what? The same philosophies, the same jurisprudential viewpoints, the same ideologies. That's what they do. So he's choosing people who reflect his thought. So don't be surprised decisions like this go in the favor of the ruling government. And it's not only MPP that does it. NDC too. Some judges here, when you are in office, you choose your friends to go to the Supreme Court. Then you say, oh no, it's the ideology, it's the jurisprudence. Yes, you want similarity in jurisprudence. That's what we mean by friendship. So this matter, all I'm saying is that there is no right or wrong answer. No, there is no right or wrong answer. But ultimately, it's all about the one who has the power. And the one who has the power is the Supreme Court. And they say a jurisdictional issue. I don't see it. It's a ruse. Listen. The reason I disagree is that the purposive interpretation that you hear the lead opinion, Justice Asare Daku himself invokes. Yes. One of the cardinal principles of the purposive interpretation rule, the starting point is that take the words, okay, give them their ordinary meaning in the context. He's quoted it all. Then as he goes on and on and on, he's not staying faithful to it. He goes to bring the history, okay, selective history. So you see, it's not complete. He chooses the ones that reinforce his opinion. Okay, so it's not like a strict science. Though law is a science, but that's a social science. It's not like the this physical sciences where you say, okay, one molecule of hydrogen plus 2 molecules of oxygen will give you what? Water. No, the law one, though we say it's a science, it's not as strictly physical science as the one I just described, right? So their viewpoints and all those things are written in because he says he's doing purposive interpretation. Now, when you read the words are very clear. Who has asked you to go and resort to history and the rest? No, read the first words. They are very, very clear. And so in interpretation, we have the principle that, listen, there's a distinction between undesirable law and then unconstitutional law. If you are saying that what we are faced with is that the court is saying the law is undesirable. But be careful, the same Supreme Court, you hear Kluje, Datiba, and even from the 1979, you hear Fatal versus Minister of Interior. They make it clear. The fact that law is undesirable doesn't mean you should strike it down. No, if it's very clear, it's clear. Too many Supreme Court decisions. When the law is clear, just leave it at that. Don't go and resort to esoteric meanings because as Justice Asare Daku wrote, then he bound himself, entangled himself in so many things that were unnecessary. Look, let's go here. What is difficult about if he was elected a member of parliament as an independent candidate and joins a political party? What is difficult about this?
That's Article 97.1.
Yeah, 97.1.
G.
Yes, J. No, that's H. I'm talking about Isiama. What is difficult about this? Then you go to our history, and some people, Dr. Gladys Unsowa, who, there were people who, in the term of parliament, they switched, and then nothing happened. Meanwhile, the same Supreme Court has held that when an unconstitutionality goes on for even hundreds of years, it doesn't ripen into constitutionality. Justice Asare Daku goes on to say, no, if we allow this thing to stand, then it means that the constituents will not get a representative for the last 3 months. That's wrong, and that the Constitution intended that at all times we should have a representative. That's wrong, but within they say, excellent, yeah, you are talking about the same Supreme Court, June 2020, they saw it coming, that the decision they gave in the Valentine, Jache, Sametepe, that Sal, Central Kofi, Akpafu, Lolobi, and Likee will not get an MP. They didn't make an exception. Jachi Kesi. So many examples. But you see, so Justice Asare Daku goes on to say that the Constitution intended that we should have a representative the constituent should have a rep all the time, but that's not true. The same 97, okay, makes provision for what? Resignation. So is he saying that when a member wants to even resign within the last 90 days because the constitution wants the constituents to have an MP throughout, that member cannot resign? It's provided in 97 here that the person can resign.
Yes.
If the person absents himself for more than 15 sittings, he can be removed, okay? And then if he's found guilty of contempt of parliament, these are all there. And so
the reference you make is what is on the screen there. So on the HS, you make reference to Andrew Siama's case. If the member was elected as an independent candidate and subsequently joins a political party.
Yes. Yes, thank you.
97H. In the reasoning of the Supreme Court, such decisions, the consequences of it, to the extent that the person's decision is of a matter of a subsequent election, an election that is in the future and not of the now, the consequences of it cannot be suffered in the parliament of the moment. And that if the person's decision affects the 9th parliament, then the consequences of it should then be applied in the 9th parliament. But if you look at the speaker's reasoning, and Council Martin Pebu, the speaker says, if the consequence of violating Article 97 is of futuristic, implication, then there will be really no punitive measure, because if Andrew Siama eventually wins the 2024 election in Fomena, he's going to serve with the NPP.
Wrote. He says that for the majority, he says the framers of the Constitution intended constituents to have uninterrupted representation throughout the parliamentary term, and any interpretation that undermines continuous constituent representation during a parliament's term is constitutionally untenable. That's false. That's not what the framers intended. 97 itself has provided that MPs can resign and MP can be what? Expelled from parliament, etc. So this statement, this cannot be correct. That's what I said. You see, when the situation is not ripe and you force it, you have to explain. Then that's what the young people now in this court, you go explain tire, right? Yes, look at it. He said the framers intended that they should have uninterrupted representation throughout. It's not true. It's not borne out by 97. It's not borne out. Yes, you would, but there are exceptions. If you fall foul of the law, you'll be removed. And so if you are removed, and Article 2, Clause 5 or 6 says that 90 days to an election, if there's a vacancy, no further by-election. So this is not true. That's why I said that what we have here is a situation where you've given power to somebody, and that's the person's prerogative. That's all. But as for explaining and trying to justify, I'm clear that I'm not persuaded. Look, so it says that, look at the 112 I mentioned, 6. It says, notwithstanding Clause 5 of this article, a by-election shall not be held within 3 months before the holding of a general election. So will you strike this 1-2 down? The top, you see the explanation, the judgment was labored. The majority judgment, it was labored, was struggling. I said, no. So the thing is very clear. So let me land on this point. It's very clear. And so you see why then lawyers have raised arguments that this decision takes us back to the powers of the Chief Justice to empanel. Because doesn't it strike you that the senior-most judges were left out? You see, Mr. Ansari made that argument the last time. Bafu Boni, who is the most senior, yes, he is left out. Puama, next, left out. Is that the only case? What are you saying?
Wait.
What are you saying? You see, as if I say why?
No, cancel land because
yes.
I need to.
Is it so? HPC prep.
I daily update TV, so then I'll share and subscribe to YouTube channel, like and share and comments, so conversation. You better brain your committee for any extra for you know what is. Now, and some of the and some of the and quad die and I say, or maybe Debbie, and some of the still now. I'm paying for attendance or Montias here, and I say, Omonia Omo agree with the ruling of the Supreme Court because even the two justices is not agreeing to a decision of the court. Woman say, and you're right. And you're right, into normal, they disagree with the ruling. I was here. I daily update TV, so say they make no subscribing or share now the comment and so. I shall comment section. If I do bring PP in some more, I'm not sure for native for you know, stay tuned.